It's a great day. I'm Diane Luongo-Gazich with Diversified Capital Funding. Thank you so much for joining me today on DivCap TV. I have invited Robert Von Esch, goes by Rob, he's a business real estate attorney and has been in the business for 11 years. Very knowledgeable in what he does. I've worked with Rob on a few transactions in the past, and I just thought he had some great information to share with you. A couple weeks ago, we had him speak at the Yorba Linda Caravan, and he talked about changes in contract law. And so I wanted him to explain that a little bit to you. Rob, can you kind of enlighten us a little bit?
Absolutely, thank you. There was an important case that came down through our California Supreme Court in 2013. That case is commonly known as Rivera's Land, and attorneys everywhere are talking about Rivera's Land because it made a fundamental change to contract law in court as we know it. Traditionally, there is this rule called the parole evidence rule, and what it does is it bars the use of extrinsic evidence in interpreting the contract or enforcing the contract. So for example, let's say you have a fully written contract signed by the parties, but before the contract was executed, there were emails or text messages or other types of evidence that could be used to interpret what the parties intended to do. But say, for example, those things contradict what is in the fully executed written agreement. The parole evidence rule used to prohibit those other sources of evidence, those emails, those text messages, and those other forms of evidence from being used to contradict the terms of the written agreement. Well, Rivera's Land came down in 2013 and said, well, wait a minute. If somebody is going to argue that there was fraud, we're not going to preclude the use of those extrinsic forms of evidence. So that's a fundamental shift in contract law. And this becomes very important because now people are going to simply say, anytime there's a breach of a contract, that there was some form of fraud. And in the real estate world, you'll see this in terms of claims being made for failure to disclose, misrepresentation. So what if those failures to disclose or misrepresentations are items that contradict what was in the actual written agreement? Well, now those forms of evidence might just be admitted into court, and that carefully drafted contract might not do all that it was designed to do to protect you. So this is a big change in contract law. My suggestion would be to use what's called an integration clause, which, by the way, the California Association of Realtors Standard Purchase Agreement does have an integration clause. It's section 28 for most of those form agreements. Problem with that integration clause is it's mixed in with other types of provisions as well, so it's more of a general provision. I think if you want to avoid Rivera's Land type challenges to your ironclad written agreement, you need to beef up that integration clause. It needs to specifically say the parties are not relying on any representations made outside of this agreement. What is said here in this agreement and in the required Civil Code 1102 written disclosure statement is the deal. There's nothing else outside of this, and I think the party should specifically initial that provision. That way, if you do go to trial and somebody tries to say, well, there's fraud, so I want to bring in this extrinsic evidence, which again would be those emails or those text messages, you as the attorney representing the party that's being sued for fraud can say, well, wait a minute, plaintiff. You specifically acknowledged right here in this contract that your entire understanding of this deal was laid out in these written documents that the parties signed. That was what you said and you specifically initialed. Now here you are saying, well, that's not the case, and all of these other things were said outside of the contract. So it would really give you, as the defendant being sued for breach of contract and fraud, a lot of very valuable information or ammunition to use at trial to refute those plaintiffs' claims. So Rivera's Land, again, is a profound change in contract law as it applies in actual litigation and court context, and the, I guess, remedy or the suggestion to combat Rivera's Land, again, would be to have a very robust integration clause in your contract that is specifically initialed by both of the parties.
Now, you had also mentioned before that that includes verbal agreements. If someone says something verbally and it's interpreted as part of the contract or an agreement or an interpretation, does that clause that you're talking about cover any verbal, or should you be stipulating that in the
Yeah, in fact, a verbal agreement would be another form of extrinsic evidence. So I used what I consider to be typically stronger examples of extrinsic evidence, such as emails or text, because there's an actual record of something being said that you can show as an exhibit to a jury or a judge. But oral representations are other forms of extrinsic evidence. In fact, they're weaker forms of extrinsic evidence. So if your defendant in the fraud case was basically limited to using oral representations as his supporting extrinsic evidence, that would be a weaker case, in my opinion, than had that same litigant come forward with emails or texts that contradict the written agreement. But either way, it wouldn't matter. Those are all forms of extrinsic evidence that are covered in that Rivera's Land decision that I was speaking of.
That's really, really informational. Rob has given us an article that we've attached here as well that you can have. And Rob can be reached at?
You can reach me by phone at 714-456-9118 or rob@voneschlaw.com, which is V as in Victor, ONESCHLAW.com.
And I thank Rob again for coming and sharing this valuable information with me today, Rob. Again, business real estate attorney Rob Von Esch. Thank you so much for joining us.
Thank you.